Okay. What's the state's take?
Your Honor, well, just to provide a little background on this, with regard to the IADA, the Interstate Act Agreement on Detainers Act, um, right around August of 2023 was, I wasn't assigned this case. It was Miss Dushan's case. Before me, she received a request, uh, and it was served on her from the defendant, uh, complying with the IADA requesting for a speedy trial and be brought to trial. Um, those cases, she was left our office, and those cases were reassigned to several different individuals. All of her cases on around the end of September to October of that same year. Um, and because the defendant he was imprisoned for possession of child pornography at the time, his case did not come up on the docket. So those cases were put essentially
Which cases?
the case that were divided out, including Mr. Wyndham's here. I had three of them, and they were then obviously placed in my filing cabinet to review when he comes up to docket to look at it. Um, I wasn't aware that Miss Duchamp had been served with the paperwork. Obviously, the 180-day term there starts from that day for him to be brought to trial here in the county where it was filed. And when I did review the case after Mr. Crenshaw sent a letter, as well as the federal prison it was around December to January, essentially the 180 days was fastly approaching, and we were not able to get the defendant back from federal prison because of the trying to get them moved was a process which our investigator, Mr. Crowder, tried to do, but we weren't able to do that in time. But when Mr. Crenshaw filed a motion on that to dismiss the cases, I did review the cases at that time. I had not been able to review it prior to that time, and because he had never come up on docket. And when I did review it, I looked through the case. I agreed with him that those cases should be dismissed based on the IADA. However, also looking through the case, there were other there was other actions and other that had taken place the night of this incident that were a case was not filed out of it, and that was genital to genital touching there, and obviously it's a first degree charge as opposed to the second degree charges that were filed. That was missed by the prosecutor. I would have filed that anyways when reviewing this case. I certainly would have filed the other charge on that. So I did, in fact, have Mr. Wyndham was indicted on that. I dismissed the other cases. That was
This one here,
let's see.
24 CR 1937.
Yes, Your Honor.
We're talking about
Right. The 1937 and 1938.
and 1938.
Yes, Your Honor.
What days were those indicted?
9/11/24.
So
Yep.
another 180 days has passed.
No, he's not. He was not in there on the. He had to refile another charge on these. These were not. He was not indicted at the time that was filed.
I understand. But I'm just pointing out to the court that the 180 days is kind of the magic number and another 180 days has passed is all. So.
Well, I don't think that has any. In fact, the case law doesn't say anything about another 180 days unless he refiles again that motion based off of these new indictments, which nothing's been filed from him on his side. And we were more than ready to have him ready for trial within those 180 days. In fact, the 180 days has passed. We've had this continued several times where you haven't been available, Mr. Gertz, I believe, multiple times. Well, when we're bringing up the 180 days, I would like to be clear as to why it's been 180 days. And I agree, Your Honor. I would like for this, after this hearing, for this to be set on the trial docket, and we will quickly have this case tried, and we will give him his speedy trial. But this case, again, arose out of different actions that he took later that night, and especially 1938. Yes. No, 1937, Your Honor. And that's the general contact. The other indictments had alleged it earlier in the evening in that day where the defendant had touched her. So as far as our argument that we have not tried to delay this in any way, that was a charge that I would have filed anyway in reviewing this case. There was another prosecutor who had the case before me. He was not detained on these charges. These are new indictments, and he was not detained on those charges. And this is not in any way meant to delay the proceedings. Like I said, we are ready. We can be ready as soon as they want to be. I have all the witnesses ready in these cases, and we're ready to go to trial. So this is no way trying to delay this or, do anything fraudulently here. We are also looking at the Texas case law regarding child cases. I think it's clear that as far as the intent with allowing is to allow different prosecutable units for each offense, for each actions there. And let me see. In fact, where there's one where there were different additional crimes perpetrated against different body parts by different acts. And the appellate there could have been prosecuted for all of them, which this again alleges, the new indictment alleges different actions. Although they were on that same date, they were later on that evening where it was actually a genital to genital contact at that point. And that was not indicted before. That was obviously missed. And had I reviewed this earlier, I certainly would have done the same thing within the time frame.
What's the statute of limitations for this?
There's not one
Not
already, so
Yeah,
I didn't think
so.
Yes.
it's not a statute of limitations issue.
Are these new cases part of the same criminal episode?
Yeah, I would argue, just like on this other case law, he had touched this child earlier in the evening. There was a break in that. Later on that night, when she was sleeping, she says that there was genital to genital contact later that night. I'd argue those there are separate, and they're not only are they different body parts at this time, causing his body part to touch her body part at that time. In 1937, excuse me, 1938, Your Honor. In 1938, the indecency with the child that occurred on May 19th, 2013, I will concede, I will dismiss that case because it was actually, it looks like it's the same exact, again, actions that was re-indicted on. However,
Which cause number?
that's 1938. However, 1937 was, in my eyes, completely separate and based on the case law from Askins v. State, Patterson v. State, Your Honor, where it's saying multiple sex acts may be punished separately. And again, I think it's clear on that these can be charged, obviously, separately, and especially there's special attention given and leeway for these sexual offenses, especially against children.
Can I respond, Judge?
Yes.
The court asked the question, are they part of the same criminal episode?
Why do you think I did that?
Sir?
Why do you think I did that?
Because I think the definition of same criminal episode is in section 3.01, and it says, regardless of whether the harm is inflicted on more than one person or item of property, the offenses are either one committed pursuant to the same transaction or pursuant to two or more transactions that are connected or constitute a common scheme or plan, or the offenses are repeated commissions of the same or similar offenses. And I would argue that both of those definitions apply here, Judge.
Okay. Um. Anything to respond on that?
Or I would just offer again that Hernandez is also Hernandez v. State, where it's for different offenses we're allowed to.
Is that an IADA case? Or is that just a indictment? Mhm.
And I believe there are several cases, Your Honor, dealing with the IADA where it discusses specifically whether or not those cases were indicted at that time. And these cases were not under indictment at that time. And if they were, I'd certainly agree if any way they were charged. However, this was not charged. This was not the same prosecutor on this. I would still agree if that prosecutor missed it and somehow just tried to file this after the fact. But I didn't see this until, like I said, he was in federal prison. This was never even on the docket because of that until that point. So once I did see it, I reviewed the case and
I don't think
And
you're
Judge,
the personally being berated.
I'm not attacking Mr.
no,
Floyd.
no, I'm not saying that. I'm just,
And I would point out though that these were the information and the allegations that were made that are then contained in the subsequent indictments were known to the state of Texas, were known to this district attorney's office. Again, not Mr. Boyd's fault or his, he didn't do anything wrong here. But I think the information is imputed to the DA's office as a whole. And
Okay, here's what I'm gonna do, because I really haven't looked at this. There's a lot of stuff here. But I'm gonna give everybody an opportunity within a week to provide any additional case law or materials
yes,
that will help me make a decision on an informed decision on this issue. I want to do this in a week. Can everybody do that?
yes, sir.
Judge, I'm out of town next week. I'll be
2
back on the
weeks?
7th.
What do you, what, how much do you need?
I don't mind briefing
Give
it.
me the math. How long do you need?
That's 2.5 weeks.
3 weeks. Is that good? 3 weeks, is that gonna do for everybody? That's within.
If we put it on that Wednesday of or the July 7th or July 9th, that's great.
July 9th?
Mhm.
Okay.
Okay,
We'll make that work.
okay, yeah, and I'm gonna look into these issues as well personally, but that gives me time to research this. So you're gonna dismiss 1938 right now,
That's correct, Your Honor.
and then it'll be 1937 is the surviving indictment here.
Yes, Your Honor.
Okay. Does everybody agree the term episode has a lot to do with the court's determination?
I agree, Judge.
Yes, Your Honor.
Okay.
Thank you.
Thank you. Reset. All right, Brittany,
Yes.
thank you. Dewan Cheney.
Your Honor, I believe that motion is to be dismissed. You all can see
I don't know, who's the lawyer on that one?
Mr. Laird.
Mr. Laird. Dewan Cheney?
Yes, sir. The underlying new offense, the marijuana, 4 pounds of marijuana is not to be found anywhere since 2023 when it was mailed to a laboratory, never made it to a laboratory. Nobody knows where it is. Postal inspector looked.
Thanks for watching. Make sure to hit that like and subscribe button for more crazy court hearings like this one.